Welcome to the Latham and Watkins Forum at NYU School of Law with our topic, Social Media, Government, Jawboning, and the First Amendment at the Supreme Court. This event is also co-hosted by the Reiss Center on Law and Security and Just Security. I'm Ryan Goodman. I'm a co-director of the Reiss Center and co-editor-in-chief at Just Security. So first, just a quick housekeeping matter about CLE. This event has been approved for one New York State CLE credit in the category of areas of professional practice. The credit is both transitional and non-transitional. It is appropriate for both experienced and newly admitted attorneys. For those seeking CLE in person, please remember to sign both in and out in the sheet by the door. For those seeking credit virtually, I'll be announcing the code later in the program. So I thought to start with a few extra words than normal in trying to describe the topic for today, because it raises a certain set of complicated questions and issues, and it'd be good to just kind of level set. So about 2 weeks from now, on March 18th, the Supreme Court will hear oral arguments in Murthy v. Missouri, in which the justices will consider under what circumstances government communications with social media companies are so coercive or intertwined with the social media companies' content moderation decisions that those government actions may violate the First Amendment. This practice of government actors pressuring private actors to make decisions with their companies has become known as jawboning, and in this context, conceivably a form of censorship by private proxy or state control in another industry. The issues cut across ideological and partisan divides. They are thorny First Amendment questions, and the role of government's use of the bully pulpit and more could implicate Republican, Democratic administrations, Republican, Democratic policies, and the like. There's no clear partisan line to this. The plaintiff's case, a group of social media users along with Missouri and Louisiana alleged that officials across the executive branch, ranging from the White House to the Surgeon General to the CDC to the FBI and CISA, the Cybersecurity Infrastructure Security Agency, coerced or colluded with social media platforms to suppress disfavored speakers and content, the speech having to do with the COVID-19 pandemic, foreign interference in the 2020 election, and yes, Hunter Biden's laptop. In July 2023, a federal judge in the Western District of Louisiana agreed with the plaintiffs. The court also issued a sweeping injunction prohibiting a large swath of federal officials and agencies' communications with companies with a sort of proviso or carve-out for national security issues. The Fifth Circuit upheld the district court in large part with a narrowed injunction. Its injunction said that the US government shall not, quote, coerce or significantly encourage social media companies to remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected free speech, end quote. The Supreme Court stayed the injunction and granted cert, and now faces a complicated task of line drawing that our panel will explore in detail. When does the use of the bully pulpit and the attempted persuasion of private actors become coercive? Do the facts cited in the district court and Fifth Circuit properly represent the power relations between the US government and social media companies and what went on? And did the Fifth Circuit and the district court properly apply the tests of coercion and encouragement to the alleged facts? Our panel is basically a dream team. We thought who would be the best people to speak on this issue, and all of them said yes. So I'll just say a few words about the panelists, and if you're here to see them, if you're doing this virtually or here to be with them, if you're here presently. So I'll just say a few words, and I just want to thank the panelists for spending their time, especially since they have extraordinarily busy schedules, with us today. So Kathy Ruemmler is the Chief Legal Officer and General Counsel of Goldman Sachs. She served as former White House counsel for President Barack Obama. Jameel, Jaffer, to her left, is Executive Director of the Knight First Amendment Institute at Columbia University and also Executive Editor at Just Security. Colin Stretch is Chief Legal Officer at Etsy and former General Counsel of Facebook. They come at this issue with deep experience, thoughtfulness, and a different range of perspectives. So after I ask a few set of questions in which we'll get a conversation rolling, we'll also have time at the end to open it up to questions from the audience. So just to begin the conversation, and this could be to any of you, Jameel, I might invite you first, but then Kathy or Colin as well. What is at stake here in the Supreme Court's opinion? Do you think a lot rides on the outcome, both for social media companies and potentially for other industries more broadly, because the idea of using the bully pulpit or persuading private actors, private companies to bend to the interests of the executive branch on one policy or another could obviously be in a range of other industries, not just social media companies, not just the First Amendment. So if one of you would like to start that out, or maybe Jameel.
Go for it.
Sure. Do I need to get it on, right? Okay, well, so first, thanks for the invitation to speak on this panel. So let me start with something that Ryan, you said in your intro, which I think is very important. That this case, has a particular partisan valence. It's important to kind of get that out of your heads, because the same issues that are presented in this case with Republicans on one side and a Democratic administration on the other, the next time around is going to be presented in a very different way. And you can just imagine if, say, in the summer of 2020, the Trump administration had engaged in a concerted effort over the course of multiple months to persuade the social media companies to take down speech that was supportive in some way of Black Lives Matter. Imagine that campaign included some public statement. Say President Trump went on TV and he said the social media companies are killing people by not taking down speech that is incendiary or encouraging people to act lawlessly. They're responsible for violence against police. And imagine that some of those communications were public, but others were private, and that some of the private communications were accompanied by threats, maybe extremely vague threats, maybe implausible threats, but nonetheless accompanied by threats. Or you could, spin out another hypothetical relating to speech relating to reproductive freedom post-Dobbs, or today speech relating to Palestine or Israel, right? So pick your category of speech, change the actors, and try to see this in a principled way, even though the facts as they're presented to the court really are straight out of the culture wars. So that's one thing, and I maybe that's an indirect response to your question, Ryan. Like, how significant are these issues? I think that these are really significant issues, and whatever the court says in this case will have implications that go far beyond these particular circumstances. FIRE, the free speech organization, filed a brief, which I don't entirely agree with, but it very usefully lists other contexts in which government actors, both Democrats and Republicans, have engaged in efforts to pressure speech intermediaries to change their policies or take down speech or leave speech up. And it's a long list. It's a long list. So that's not to say I think the answer to this, this particular case is easy. I think this is in some ways a hard case. We'll get into it. But to answer or at least part of your question, Ryan, I think it's an important case. It's going to have real implications, not just in this context of public speech relating to public health, but also speech relating to all sorts of other things.
Do either of you want to weigh in?
Sure, I'm happy to. One of the things that I think is most interesting about this case that makes it different than the hypotheticals that Jameel set forth, which I agree. I mean, that you do have to think about really the broader implications of whatever the Supreme Court might do, as opposed to the particular circumstances presented by this case. But one thing that I thought was interesting when I was reading through the lower court decision and the appellate court decision is there really was no recognition by the courts that the vast majority of these communications between the government officials and the social media companies related to a global health crisis. Mm-hmm. And that, I think, is really critical because, if you think about what is the purpose of the government, why do governments exist? It's really, to protect the health and safety and welfare of its citizens. And so this was really a crisis situation in which the only way to get this pandemic under control was really to get very significant parts of the population vaccinated. And so, I think that it is fair to say, and just as I'm, reading between the lines in some of the communications, and we're going to get into some more details, but that urgency of the officials in really trying to make sure that misinformation was not being broadly disseminated to the population in the wake of this crisis, I think makes this case much more difficult in some ways than some of the hypotheticals that Jameel put forth.
I would just add from the industry point of view, I think what these services mostly are trying to do, I mean, they're trying to do a lot of different things, but in this context, really what they're trying to do is prevent their online services from essentially contributing to or resulting in offline harm. That's sort of the basic principle that tends to govern and has for a decade or more the kind of the going in perspective on, are we going to moderate content, and if so, how? When I think about what's at stake, I mean, I think it's so interesting. It was a global health crisis. Hard to imagine anything sort of more important with more possibility of offline harm, so more relevant to that lens. Also, somewhat bizarrely, it's still kind of hard to wrap your head around why it became so politicized, and yet it was acutely politicized, and that's often not the case with the possibility of offline harm. So for example, the government talks a lot about terrorism and child safety. Those are important moderation contexts that are typically not as politicized, where these questions don't come up as in the same sort of frame. The point I'll make is that when the companies are doing this, they're doing this in a lot of different lanes. They're technology experts. They're not terrorism experts. They're not child safety experts. They're not health experts. And whenever they choose to sort of wade into a topic, they have a lot of learning to do. And how do they learn? Well, they talk to people. They talk to experts. There's lots of NGOs who have contributed enormously to these content policies and the enforcement decisions that these companies make. The government's probably the best resource on most of those topics. So when I think about what's at stake, I think about, God, that'd be a real bummer if you were trying to do that job and you weren't allowed to talk to the people who are most informed. And if you can sort of lift out of the, as Jameel said, the politicization of the issue, it becomes, in my view, a relatively straightforward case. Do you want the companies to be able to talk to the government about this stuff? Do you want the government to be able to talk to the companies about this stuff? I say yes.
Can I? Okay. So
we're going to join issue sooner rather than later.
I think that's right. Yeah. So okay. So first, let me just say I'm very sympathetic to the Biden administration in that particular episode involving vaccine information. I mean, I think that the Biden administration had a responsibility to counter vaccine information, had a responsibility to, in some way, alert social media companies when what the Biden administration saw as vaccine misinformation or public health misinformation was being disseminated on those platforms. I'm very sympathetic to all of that. But here are the things that make this, I think, maybe a more difficult case than Kathy and Colin acknowledge it is. So first, I don't see a real distinction between a public health crisis and what the Trump administration would have characterized as a civil unrest crisis or a law enforcement crisis. And I think, after, say, the Snowden disclosures, the Obama administration would have characterized those disclosures themselves as a kind of sparking a national security crisis or themselves a national security crisis. And so I'm not sure that we can cabin, I worry about whether we can cabin any rules we come up with in this context to the public health context, even though I'm very sympathetic to the Biden administration on that particular set of issues. So that's one thing. The second thing is, it's true, even if you can cabinet, right? Even if you think, well, public health is different, a public health crisis, the government needs to have the power to to talk to the public, to talk to social media companies, to talk to other speech intermediaries, and even to pressure them and to coerce them, even if you accept, well, public health is different. We're gonna have a different set of rules in this context. Isn't it equally true that for the same reasons, so much is at stake in that context, right? So much is at stake, but isn't it for that reason also true that it's especially important that the government speech be subject to real checks and counterweights, right? And if what was going on here, and we'll talk about what actually was going on here because the facts are important. If what was going on is that the government was essentially overriding the judgment of the social media companies, then I don't think that's a good thing for. It's not a good thing for a democracy in the context of a public health crisis to have a government that has the power to do that. So, for all those reasons, I just think that this case is more complicated. Since I have the floor already and introduced the facts, I think that one of the things that the Fifth Circuit did, and even more the district court did here, is sort of lump together a lot of different things, some of which might be totally unproblematic, and others that raise real questions, and then draw kind of broad conclusions that make it in a way that makes it difficult to know precisely which facts were the basis for which conclusions.
Yeah.
Let me just leave it there.
Kathy, can I ask you to put on your hat as former White House counsel, and the question of, you could either talk about the facts that we have, or just basically from that role, what do you want to see U.S. government officials doing? What are the kinds of instructions that you think they should abide by in their communications with social media companies? What are the kinds of things that you're worried about or considering in that role? And are there red lines that you would try to instruct folks in the White House, or maybe in the departments and agencies, about what they should or shouldn't be saying by way of, and then what might be the examples are, what might cross a line of coercion, what might cross a line of threatening the company with X, Y, Z sanction or official action. Is that it? Is that what you're thinking about? What are the things that you would say, or at least should be best practices? And then we can talk about whether or not we have in the record here something suggesting they crossed it. But
Yeah, well, I think there are some things in the record here, I'll start there and then I'll back up, that I would say, I might have phrased a little differently if I were scripting people, but, so I'll say that diplomatically. But it's that the conclusions I think that the court drew, particularly with respect to, the people who were speaking, the government officials who were speaking. Let's talk about the White House officials, because I think that's where there were some pretty broad conclusions that were drawn by the court about, sort of the great power of the White House, which is, I think, quite detached from reality. And, to Jameel's point about facts mattering, if you starting look at the social media companies, I mean, these are some of the most powerful and sophisticated companies literally in the world. They have multiple former government officials who are working there. They are, while they need to consult, to Colin's point about particular subject matters, I mean, these are companies that understand kind of how the world works and how the government works. These are not individual citizens who might have, be kind of overwhelmed by getting a call from, the guy who's running the digital strategy at the White House. So, I think that is important context. And then who is speaking? Who are the White House officials that's speaking? That actually matters too. And if you have an appreciation for where the real enforcement authority lies, it's not with the guy who's running the digital strategy at the White House, I can tell you that. That guy literally has zero authority or ability to influence a decision at a federal agency that would have some regulatory authority over any of these companies. So that I think is a factual thing that matters. And I think too, when I said there are some things that I think I would have drafted differently, the comments, and just to get into the facts for a second, some of the comments that were made, I think including references made by the White House press secretary, were along the lines of, well, there could be reforms to Section 230, right? And so again, going back to the sophistication point, that's not something the White House can do. That's something that has to be addressed by Congress. And that's kind of like saying, the sky is blue. I mean, it's so obvious. There's been a lot of, public debate about whether there should be reforms there in any event. And so that to me is just kind of the idea that in some way would be coercive to this very sophisticated set of companies, I think is kind of silly, frankly. I think there was a passing reference to antitrust enforcement. That was one wearing my White House counsel hat that I think was unfortunate. And I'm being very diplomatic here. But I think the reason why I think it was unfortunate is actually not for the reasons that the court suggested. It's not because I think in any way, shape, or form there would be some enforcement action that would be brought as a result of the company's unwillingness to moderate content, but rather that if independently, which is the way this happens in the real world, there were some antitrust issue, the fact that that statement were made has now complicated the actual on the merits case that the Justice Department or the FTC might bring. So, I think that those stray comments in my mind were, again, given the audience, given the people who heard the conversations, were they were sort of political rhetoric, really to show that the White House was doing everything it could to ensure that it was really addressing this public health crisis.
Right. And I guess, Colin, can you come at the same question from circling it from the other side as from within the social media companies, what you think about, like, one of the, let's put it in this way, one of the parts of the legal test of coercion is whether or not the recipient of the communication perceives it to be threatening. Are there any ones that cross the red line or that you think about as a red line?
I mean, I share Kathy's view that these are big companies. They don't scare easy. They've got folks who work for the government or have worked for the government. So they kind of get it. And I left Facebook in fall of 19. I think 2020, 2021, I think that was a very intense time. And I do think there was a lot of pressure brought to bear. So I don't want to overstate this. But the reality is there's often a lot of pressure being brought to bear on these companies from government officials all over the world. And the question when you get, when you have an incoming is typically not how mad are they, but what are the actual consequences? It's not like, gee, they're really mad we haven't returned their email. Like, okay, let's return their email. That'll sort of take the temperature down, and you always want to try to settle it down. But the question is, like, what are they going to do? And in the U.S., happily, from my perspective at least, not that much, right? So, and I think so to me, the fact that really underscores how I think the companies would have reacted to this is the kind of the blood on the hands. They're killing people, right? So yeah. President Biden went out and said these companies are killing people, which is extraordinary, right? That's an extraordinary statement by the President of the United States. It felt, I'm sure, terrible to the companies. Certainly, these are people who work very hard every day. They're trying their best to do right by their company and by their users, and I'm sure that felt awful. And what do? Mark went out and said, don't blame us for your failed vaccine rollout strategy, right? That was not a company that was like, oh, we're going to be cowed into submission. It was like, this is on you, not on us. And that to me is as it should be, right? Whether who's right or who's wrong, I won't mediate that. But they weren't like, oh, now we're going to tuck our tail between our legs and do whatever the government says. It's sort of rhetoric. It's playing out in a political forum, and that's life in the big leagues, to sort of switch to a sports metaphor. And these companies have been playing there for a while. They're sort of okay in my view.
So, Jameel, do you want to come in on that in the sense of, in this particular case, with this particular set of facts dealing with the large social media companies, is there anything that you see that crosses this line? And in the constitutional line, and if you agree with this, is really between what is persuasion and using a bully pulpit, which in some sense that's what you could say Biden was doing by being at the bully pulpit and saying these companies are killing people, to something that's more about coercion, and that coercion is a specific threat of some kind of sanction. But then what I'm hearing Kathy and Colin saying is that that's not at play here. These are, in some ways even, the companies are bigger than the government. I mean, the power relationship here is not one in which, at least with these actors.
That's not what I was trying to say about that. But
I'll say or maybe are bigger than the particular individual found in the, like, who's doing social media content for the White House. So, or is there something that you see that is more about the principle in the case, and it's about future cases, smaller companies, other situations, other government officials?
So let me answer the bigger question first. So maybe it's worthwhile just to go back to why coercion is the line, or at least I think it's the line, and maybe everybody on this panel thinks it's the line. So I think that these cases are hard because there are First Amendment interests, or at least interests that sound in free speech on both sides of the V here. Like on the one hand, you have the interests of the people in having a government that can actually govern. And governing requires speaking, including speaking to private speech intermediaries. It includes, I think it's entirely legitimate for a government to pressure private speech intermediaries to be more attentive to what the government views as the public interest. So all of that is on one side of the V, and I see that as a kind of free speech interest because I think ultimately it's not a government speech right, it's really a right that inheres in the citizenry. It's a right of the citizenry to have a government that can do those things. And Colin mentioned this earlier, but sometimes the government has information that nobody else has. And you want a government that can share that kind of information, right? We want our government to be able to share whatever the CDC comes up with private speakers. And the same is true in national security. The government often has information that others don't have. And while the government's information is not always reliable, we want the government to be able to share that information with journalists and with others. So that all sounds, at least in my mind, in free speech. Those are all kind of free speech interests, even if we don't usually think of them as First Amendment interests. Now, on the other side of the V, you have the interests of the companies, the social media companies, or speech intermediaries more broadly, and their users in having expressive spaces that are free from government coercion and that reflect autonomous editorial decisions of the people who are in charge of those spaces. And both of those are important interests, and the way that our law reconciles those two interests or balances those two interests is through this distinction between persuasion on one hand and coercion on the other. So that's the way I see. That's where I see this persuasion versus coercion rule coming from. It's an acknowledgement that there are important interests on both sides. Applying that rule is much more difficult than stating what the rule is. Because so many facts might be relevant to whether something is coercive, right? It might have to do with the tone of the communication. It might have to do with whether there was a threat, whether the threat was explicit or implicit, whether the person making the threat had regulatory authority. In the brief that the Knight Institute filed in the case, we put a lot of emphasis on whether the threat was public or private. We see private communications presenting a much more significant First Amendment problem than public ones, because the private ones are not subject to other checks, right? When President Biden goes on TV and he says social media companies are killing people, lots of other people can weigh in on whether that's actually the case, whether it's the social media companies that are responsible for this, or it's the Biden administration's failed rollout, right? Whereas if it's a private communication, somebody at the White House sends an email to somebody at Facebook saying take down this post or else, that doesn't get any pushback because nobody knows that it exists. So this question of whether something is coercive, I think is inevitably a fact-intensive one. It's very difficult to come up with principles in that space. But with respect to this particular case, are the social media companies, just uncoercible? I think, a few things to consider here. One is in every regulated industry, and I think of social media companies as part of a regulated industry, even though the regulation is, arguably pretty light touch, or every potentially regulated space, you have a phenomenon which Daphne Keller has called, I don't know if this is her term, but I'm stealing it from her, anticipatory obedience, where sometimes the regulated entity or the entity that thinks it might be regulated, one of the things that's going on in their decision-making is, what happens, why don't we do it this way, just to avoid the possibility that in the future the government will regulate us more harshly or regulate us in a way that we're not regulated now, right? And I think we have to, it's hard to, prove that was, that phenomenon actually had some traction in any particular context, but I think that is a phenomenon that we've seen in other contexts, and it would be quite a surprise if it didn't exist in this one too. The second thing is the scale of the social media companies. Social media companies are so big that they just have no stake in whether, they just don't care whether any particular piece of content stays up or not, or at least they don't care very much about it. Right? It doesn't have a lot to do with their bottom line. Whether any particular piece of content stays up or not doesn't actually change the character of the expressive community that they have created. And so if you have a government official saying, take down this speech, it's just easier for a social media company to say yes. That's not to say they always say yes, they don't. But it's easier for them to say yes because they don't care that much. It's different from, the government goes to a bookstore that specializes in books for the LGBT community and ask that bookstore to take down this set of books. That bookstore is going to have a kind of expressive interest that social media companies don't have in any particular piece of content. Last thing I'll say, one of the things I think First Amendment doctrine can help do in this sphere is protect a kind of diversity, editorial diversity. If you allow the government to coerce the social media companies, we're going to have one public sphere. Like the digital public sphere is going to be the same on Facebook as it is on Twitter, as it is on every other platform, right? Because everybody will, at least at the margins, adopt the government's rules. So one thing that this rule against coercion does is protect a kind of diversity. But as a matter of practice, the social media companies often operate in a kind of cartel-like way. Now I'm stealing somebody else's work, and this is Evelyn Dueck's work. They operate in a cartel-like way in the sense that once Facebook has decided that, say, Alex Jones shouldn't be on this platform, most of the other platforms just follow suit. It's just easier to follow suit than to strike out your own path here. And so, where does that leave us? I guess I'm just saying it might be naive to expect the social media companies to be reliable proxies for the speech interests of their users.
Well, I love the sympathy for regulated institutions since I work at Goldman Sachs, which is probably in the most regulated industry, and I often feel coerced every day, but that's a different subject. What I would say, just in response to like how do you draw the lines, and I do think we sort of all agree that coercion is probably an appropriate line. It's a rule that we have in the existing case law, but in my mind, one way to do it, and I think if I were on the Supreme Court, this is probably how I do it, is to say it better be really, really clear that there was in fact coercion and that the recipient of the speech actually felt coerced. And in at least my review of the record, that's just not present here. I mean, there's really no evidence that I saw that anybody at any of these companies actually felt coerced. There's no internal emails saying, oh, if we don't do this, they're going to bring an antitrust case against us. Or if they don't do this, they're going to do X and we better do what they say. And there's not really any evidence that, anybody at the government was telling them to change their policies. They were rather saying, look, we want you to enforce your content moderation policies. There's really no dispute in the cases I can see that the content at issue wasn't in fact misleading or a misrepresentation or otherwise potentially harmful to the public. So you know, one way potentially that the Supreme Court, I think, could do something relatively non-dramatic is just to say, look, we think that there are cases in which coercion is present, but this ain't it. And, you know, that's easier said than done because they have to articulate some things. But in my mind, that's sort of the most important thing. And I think the nature of the recipient of the alleged coercive activity, you know, how sophisticated that person is that person an individual? What is the power differential between the government and the recipient? I think those are all really important factors that, frankly, the lower courts didn't spend a whole lot of time really even addressing.
So, yeah, I kept looking for the, if you read the Fifth Circuit decision, there's the whole like, wait, is correlation causation? Because they kept saying, and lo and behold, the companies got in line.
Yes.
And this content came down. And just one sort of background understanding, anytime you're talking about these companies generally, and particularly on the moderation side, it's like the scale is mind-boggling, and they're not very good at it, right? They're just, I mean, they've gotten a lot better, but it's a combination of people and machines that are trying to apply these rules that are kind of complicated across just a mind-boggling array of content, and they make tons of mistakes. And so frequently, I mean, this started happening in probably 2012 or so. We get a lot of incoming from media that would say like, hey, this is up, this is up, this is up, this is up, this is kind of like, and we'd look at it and we'd be like, oops, take it down. So is that coercion? No, that's like, oh God, we looked at it and it should come down. And so frequently what's happening is it's just drawing renewed attention on content that should have come down. I was sort of looking for the, Jameel, I think you used the term overriding the judgment of the companies. And I didn't see it. And in the absence of that, and in the absence of anything, like Kathy said, suggesting the companies were like, oh gosh, you know, there's going to be a consequence if we don't get in line. It's hard for me to see, you know, a real problem in this case. I don't want to say there's no issue here, though. I don't like. I think, you know, Jameel at the outset brought up the fact that this was sort of intensely political, this topic. Frequently, this stuff comes up in contexts that aren't political and that aren't where nobody's going to stand on the side of speech. So I think the terrorism stuff is a great example, and child safety is another one where, you know, for years the companies had policies that would prohibit anybody who was a registered sex offender from having, for example, a Facebook account or a YouTube account or various other services. So people who had paid their debt to society were effectively locked out of participating in the digital world by virtue of the fact that they had been convicted of a sexual crime, which was never the law. It was solely, at least in my experience, the result of a particular attorney general, state attorney general, who went around poking the companies and saying, you need to do this, you need to do this, you need to do this. No process, certainly no indication that the disability that this attorney general was trying to force on the companies was sort of not overbroad. And it resulted in every company adopting the policy and a lot of people being kept offline. And, you know, who's going to stand up for the registered sex offender, right? Nobody. So that's, I think, a really a good example. And I think there are probably others, particularly in the terrorism space, where you do have, I'd say, quite problematic content that is being used to radicalize, youth around the world. But, are they drawing the line where it needs to be drawn, or are they drawing the line a little bit more broadly? Because who's really going to stand up and defend somebody who's been accused of fomenting terrorism? Nobody. And so I do there are issues here. about the company's line drawing. I think in the back of all of this is, I think, the basic fact, and I think that's really what's driving a lot of this, is you have companies that matter a lot to our discourse that have very little transparency into how they make decisions affecting content and very little accountability. So I mean, that's kind of what's going on here, right? There's a deep suspicion that they're making, among some people at least, that they're making decisions with political motivation or other motivations in mind, and nobody can really test it. And that's where this case comes from. I think that's where the net choice cases come from involving the Texas and Florida statutes. I think that's where the Facebook Oversight Board comes from, right, is the company's recognition that we got to try something to create some degree of accountability. Otherwise, I mean, that's sort of a good example of, what did you call it, anticipatory obedience. It's like this state of play where there's very little transparency and very little accountability on questions of speech is that's not a sustainable situation.
Well, and the reality is that this case, it's really not a coercion case. This is a case, and what's really going on here is that the Biden administration had more influence with these companies than perhaps the Trump administration would have had. And so, it's interesting that the communications back and forth, at least in my mind, actually show a willingness on behalf of the tech companies to be very engaged, because they're sort of like-minded on this topic, because they're actually, my guess is, I'm not sitting in the thing, but my guess is that most of the people in senior positions in companies like, Facebook, what was then Twitter, it might be different, now, but we're sort of like, yes, we believe that masking is helpful to, stemming the pandemic. We believe that vaccinations, they were in some ways, they were pushing on an open door, which is why I think it's interesting that this is in the coercive frame, because I think in the real world, that's actually wasn't what was going on at all.
I mean, it's possible. I mean, I think you're right that they were in some sense like-minded, but it's also possible that they were even more like-minded because they knew that there was a cost, or there might be a cost to not being like-minded, right? And the question that Colin was asking earlier, where is the evidence that somebody actually changed their editorial position? I don't think it's possible to say with any certainty that any particular editorial judgment was made differently by one of these platforms, or at least based on my understanding of the facts. I don't think it's possible to say with certainty that any particular editorial judgment was made differently. And so if that's the test, then the plaintiffs here fail. But I guess I might approach the question a different way and ask not, can you show that there was a change in editorial policy as a result, as a consequence of the purported jawboning? I might just ask, why should the First Amendment protect this activity on the part of the government? What is the kind of rationale for, say, protecting this communication from somebody at the White House? I know this person had no regulatory authority, but somebody at the White House writes to somebody at Facebook saying, "You got to take this down," and then there's an email that follows up saying, "You're hiding the ball," and a third email that says, if you don't fix this, we're internally considering our options on what to do about it, right? It's a private email from the White House to Facebook. Now, I don't know if that resulted in Facebook doing something differently, but why protect it? What is the interest we're trying to, why does the government need the ability to send that kind of private email to a speech intermediary? Why couldn't it say something similar publicly? Or why couldn't it say it without the implicit threat? I guess I don't see the justification for distorting the First Amendment to accommodate that kind of government conduct. It's better just to say to the government, if you want to communicate with the social media companies, do it in a different way. You can share information. You should share information. You can communicate that they're not doing what you think they should be doing, but communicate that publicly so that other people can see it and respond to it.
But isn't it appropriate for the government to say to a company that has an enormous amount of social influence and authority, to say to them, you know what, you say you have these policies, you should enforce them, to kind of hold the company's feet to the fire? Like, isn't that an appropriate thing for the government to do? Because the government is one of the few entities that actually, is able to have some persuasive authority over the company. And when you start, the government's not sending those emails, which those are the emails that I thought, not so great. But, they're not sending them to an individual speaker. They're not sending them to the person who is speaking. They're sending them to this platform, as you say, this speech intermediary. And an individual person, I don't have a right to publish my content on Facebook. I have a right to publish my content consistent with their policies. And so I do think it's important, at least in my mind, analytically, to focus in on, it's not that the government is censoring speech in this instance. The government is saying, you know what, you, Facebook, are making a lot of money. You have a lot of influence on your citizens. You have a policy. You say you uphold your policy. Boy, I'm looking at this content. Sure doesn't look like you're upholding your policy to me. That seems appropriate, in my mind, for a government official to do.
I'd feel differently about it if it were public rather than private, but also, you're obviously right that at least as a matter of First Amendment law, a user doesn't have a constitutionally protected right to publish on Facebook's platform. On the other hand, a user does have a right to be able to publish on Facebook's platform to the extent Facebook wants, and wants to publish that speech, and the user has a right not to have that relationship distorted by government coercion, right? So I think it just brings us back to the question, well, is it coercive or not? Because the user does have a right not to, have his or her speech interfered with by that kind of unconstitutional pressure, if it's unconstitutional.
Yeah.
I'm pro-transparency. So I'm actually, I think, Jameel, I think you and I are aligned on this. I just think it does, I think it answers a lot of questions if they're willing to say it publicly. And then the companies can do some sort of transparency report to say, here's how frequently we, adhered to these requests. There's again, every government where at least Facebook operates has a mechanism to get requests from the government. Most of the time, those requests, I shouldn't say most of the time, a lot of the time, the requests that come from foreign governments are really problematic. They're sort of like this, this person's a terrorist. Actually, no, this person is actually a political opponent of your cousin. So, we're going to leave that up. But, bringing all of that out into the light, I think, is really healthy. And I don't really see a lot of value in enabling, as Jameel said, private conversation or private communications. It just does seem more it just creates more possibility of abuse. It reminds me a little bit of in the wake of the Snowden revelations. Again, now we're going. I like to date myself, but we're going back a decade or so. Where I think there was a lot of concern that a lot of what the government was doing with respect to gaining access to information from both telephone companies and internet companies was what just wasn't above board. It was done confidentially and not pursuant to legal process. Now, it turns out that much of that, maybe even most of it, was overblown and inaccurate, and reflected just a basic lack of understanding of the tools that the government had available to gain access to information for various national security purposes. But what I think helped really address that situation was the steps that both the government and the companies took towards transparency, right? Towards saying, here's how many requests in these different lanes that we're getting, and here's how we're acting on it. And then people could look at that and say, okay, this is a vanishingly small amount of information that's actually being turned over to the government, and it's pursuant to these legal authorities. Let's just move on. I mean, it took a few years to move on, but I do think that, it's a little hard to see exactly how that would apply in this case. But I do think that instinct towards let's regularize this, let's have channels where you can report either complaints about policy, and then the companies can decide whether to change policy, or they can flag content that they think violates policy, and then the companies can say yes or no, it comes down or not. And let's just be public about it.
I guess I want to, in a certain sense, shift to another potential legal argument avenue for the Supreme Court, which is the opposite of coercion in a certain sense, the way that's I think of it, of strong encouragement. So if we are in a realm in which the companies are aligned in their interests with the government, and the government, so it's cooperative, is there a risk, and other lawyers who are having to litigate this, thinking about the risk that if they say, actually, it's not coercive at all, it's highly cooperative, then they've kind of slid into a separate test of strong encouragement that makes it a form of state action, and then the actions of the company are attributable to the government. And it's funny, the way of thinking of it is the question presented to the court reads as, one of them does, whether the government's challenged conduct transformed private social media companies' content moderation decisions into state action and violated respondents' First Amendment rights, which in some ways even sounds a little bit more like the strong encouragement, even though I think coercion is really the heart of it. But is that something that's also something that we should think about? Have we kind of veered into that lane, or are we still in some sweet spot in between the two?
I mean, I guess I'm not very sympathetic to that particular argument for two reasons. One is factual, that I think it's important to recognize that what's going on here with the social media companies may be different in degree, maybe, from what goes on with other speech intermediaries, but it's not really different in kind. I mean, if you think about many conversations between journalists and government officials include jawboning of one kind or another, right? If you're a national security journalist and you're talking to a national security official about some secret government program and how it should be characterized, a lot of that conversation is going to be about, it's going to be the government trying to convince you, the journalist, that the program should be framed in a particular way. And I actually talked about this case to a publisher of a major media organization, and his reaction to this case was, I hope nobody starts thinking about the conversations that we have with government officials every day, because they're entangled with the government. And after the Snowden disclosures, the Guardian, the New York Times, the Washington Post all had conversations with the government about, before they decided to publish, they gave the government an opportunity to say, if you publish this, the sky's going to fall. Now, they didn't listen, or they didn't always
They said
listen,
it and they
right?
published anyway.
Yeah, well, they didn't publish everything though, right?
No, I remember, 24
And,
hours.
and the same was true in 2005 when Eric Lichtblau and Jim Risen wrote the story on the NSA's warrantless wiretapping program. Conversations between the New York Times and the government were part of the reason the New York Times held its story for almost a year before publishing it. So I'm not defending the result of these conversations, but it's a fact that journalists and editors of conventional or sort of legacy media organizations have these kinds of conversations with the government all the time, and those conversations involve jawboning. This goes back, I guess, Ryan, to something that you asked right at the beginning, which is, what are the sort of broader implications for this case beyond social media? Social media isn't the only place where jawboning takes place. So the facts here, you asked about this argument that the social media companies have become state actors because of the entanglement. I think this entanglement is not really distinctive to social media, even if it's a little bit different in degree. Then the other reason I don't love this argument is that I think about what would the remedy be. So if, let's say we accept that, Facebook became a state actor by participating in this cooperative conversation with the government about what should stay up and what should come down. What's the result? And then a court is going to issue an injunction requiring Facebook to keep up certain, information that even Facebook says it wants to take down. I guess I don't see I don't see this leading anywhere good.
I had the same reaction on the I'm traced through the sort of the doctrine, but if you look at the sort of the industry brief, which is very short, but they're basically saying, like, whatever you do, don't say that we're governed by the First Amendment, because that would create, First Amendment's wonderful, but it would create a massively permissive set of moderation decisions where, you couldn't take down anything or just about anything.
Well, I was going to say
short
that
of,
the
obscenity
plaintiffs
and
with the
fighting
best
words.
argument would be the registered sex offenders on that score.
Yeah.
Because there's, I mean, there probably is really a much stronger evidentiary case for like, real, such coordination that it's almost entanglement. So
Yeah.
that would be a perverse outcome, no pun intended.
So I have one other question, then I'll open it up to audience questions.
Can I just say
Yeah,
one thing about the
please.
first question that was presented? Because I think, to me, it's super fascinating, which is the question of standing. If there's no sort of coercion, putting the sort of entanglement thing aside, but there's no coercion, then it strikes me that there's no standing, right? Because there's only an injury, in fact, if in fact there's some First Amendment violation. And there's only a First Amendment violation if, in fact, the government has caused that violation. So it'll be interesting to see how the court sequences, the first question presented is, do they have standing? It's not entirely clear to me that they do.
I was picturing sort of a trial where the Great Barrington Declaration, the validity of it actually gets litigated. Like, is it misinformation or not?
Yeah, right, exactly. I mean, it's a very, very interesting thing, is because you have to, there is no injury if you haven't found that the government was, responsible here for, quote unquote, censoring the speech. So I don't know how they're gonna figure out how to sequence that at argument, but anyway, I was fascinated by that.
And it's also fascinating just in terms of the entire conversation that you have to always think back that the social media companies are not the plaintiffs in the case.
Right.
They're not the ones saying, we are aggrieved, we were coerced,
Exactly.
and it comes up for the standing question as well, of
Yeah.
course. And that is also the segue to the one question I was thinking to ask you all before opening it up, which is to wear the hat of prediction. So how you think the court will rule, and in part because, going back to, I think, maybe one of the very first things that Jameel said, that this particular set of facts comes out of the culture wars. There is a lot of raging disinformation that I think informed the district court judge's opinion, including like the role of Fauci, the role of the FBI, and the Hunter Biden laptop. So there's that part of it as well, in terms of like, this is such an unusual case in which I think we might actually have a Supreme Court ruling or concurring opinions or dissenting opinions that are based on disinformation itself. And it's the technological capacities of the justices and their clerks to be able to grapple with this particular set of cases, in the sense of the Fifth Circuit, for example, conflates what it means to demote versus to take messages or content off of their platforms, and they conflate the two in their own analysis, and that's being pointed out by others. So where do you think the Supreme Court might land on this, given that it's got some of the similar kinds of technological problems that they've faced in the past and have dodged, and it's also got this other kind of cultural wars element to it, so they might not perceive it as non-ideological and nonpartisan? Any sense of where you think this will end up, or what we'll see in the oral argument itself?
My prediction is they're going to try to drastically simplify this case. And I think that they'll reverse the Fifth Circuit, and I think that they will probably try not to pronounce a new rule, would be my prediction.
Just want to go down, or Jameel and Colin, or Colin and Jameel? Everyone.
Should we
I
bet?
think Colin's prepared to answer the question. Wait, no, I'm not. So.
I would,
Yeah, it's not really fair.
yeah, I
It's
think,
not.
yeah, it doesn't seem like, look, I'm not a scholar in this area, so I don't know how much the courts are crying out for clarification between sort of, where the coercion line is and whether the significant encouragement test needs to be sort of updated. I'd like to see him go off on standing. I'd like to see something approaching, a significant majority. And I do think, though, to my earlier point, I just think there's deep skepticism and concern among some members of the court about, and you saw this at oral argument in net choice cases. And I think the fact that those are being argued in such close proximity, I think it matters. I think there's deep skepticism about the way in which these companies censor speech among some members of the court. And so even if they do sort of resolve the course relatively narrowly, I would expect to see somebody saying something reflecting that concern.
Yeah, the short answer is I don't know how the court's going to come out, but one thing that I think is clear from the net choice argument and from previous social media, the Gonzalez argument and the Tomna argument, multiple members of the court on the left and the right are struggling with this question of whether the doctrine we've inherited, the First Amendment doctrine we've inherited, is actually adequate to this new factual context. And in particular, this question of whether it's enough for the First Amendment to be concerned with the speech intermediaries, or whether the doctrine needs to somehow accommodate or be sensitive to the speech interests of the users, right? Who, according to existing doctrine, it's the relevant question is whether the speech intermediaries have been coerced. But if you are skeptical that the speech intermediaries are reliable proxies for the expressive interests of their users, then maybe focusing myopically on the whether the platforms were coerced is not adequate. You need to have a doctrine that somehow accommodates the speech interests of the users. And I think that the court was struggling with that question in net choice, where these two state governors, these two states, Florida and Texas, have enacted social media laws that are purportedly about protecting the free speech interests of the users. That even justices who seemed skeptical of those particular laws seemed sympathetic to the idea that, well, maybe something does need to be put in place to ensure that this handful of social media companies that have become gatekeepers to the digital public sphere, something needs to be done to ensure that those gatekeepers are actually representing the interests of their users. And I think you see that across the political spectrum on the court. I don't know what that tells you about what they're going to do in this case.
Great. So I think there are two mics on either end if anybody would like to ask a question. Right.
I'm Randy Milch. Thank you for having this session, and it is a dream team. I find myself oddly, perhaps for the first time, in deep agreement with Mr. Jaffer. I would like, we have a history. I would like to ask you to, it's the fate of any senior person at a public company to be threatened by government officials. I can't tell you the number of times it happens. So I'm not worried about senior officials being threatened by government officials, although I do carve out regulatory officials, and you've had that. It's a much different kettle of fish. I think we ought to reconsider the importance, though, of the intertwining, the second potential route for government transforming action into government action, because I think that the reporter scenario that was played out, reporter-publisher scenario in mainstream media, is vastly different than the way a large corporation is going to deal with a repeated set of government interactions, right? In my experience, what happens is that these things tend to get routinized. If there's going to be a consistent private bully pulpit, let's give it that name. I don't understand how there's a private bully pulpit. It's sort of inconsistent, internally inconsistent. But if there's going to be a consistent set of communications where the government is going to be telling you these things are you're not doing a good job with your content moderation, which I think once it starts is not going to be limited to a really severe crisis, because the crisis is going to continue to be less critical all the time, and the government's going to get used to doing this. The company is going to get used to doing this. This gets routinized. It gets routinized by pushing the interaction down in the corporate hierarchy to people who will not lie and say, of course I'm sophisticated and I'm not coerced by the government. You know, what general counsel are you going to find who say, oh, I'm so unsophisticated, I'm coerced by the government? We're all going to say we're totally sophisticated and uncoerced. But the guy and the woman who's like an assistant director or someone else, have someone from the White House call them up and say, you're not doing a good job. That, I think, is something to be worried about, right? Because the interaction, the intertwining is going to happen at a level, and then there's going to be a frequency, and then people are going to get used to it. And before you know it, there are going to be decisions that are going to be changed by this consistent interaction with the government. So I would ask you to rethink the notion that that part of it is unimportant, because I think that these things get routinized in a way that strips it of the ability of more sophisticated people to say no.
I think, just to respond to that, I mean, I think that's a fair point. I just don't think that's a First Amendment problem, or that's something that we should be, I think it's that maybe is a question of should there be, a regulation that in some way restricts, or, a statute in some ways, it would have to be a statute to apply to the whole government, but that, restricts the way in which government officials interact with private companies. But that strikes me as this, yes, an absolutely real dynamic, and it isn't fair to just say there's no coercion, because there clearly is. It's clearly influential at a minimum, right? Even with people at senior levels, there's at any company, they're going to pay attention to what a government official says. So I agree with you on that principle. I just think that, I'm not sure that the remedy is, well, we should deem the government basically censoring speech. So, but that's a fine distinction.
So the dynamic you described, I think, is very real. I think it's accurate. I think you stated it accurately. And I'm sort of sitting here trying to think about why it doesn't bother me that much. And I think the reason it doesn't bother me that much is that it is important, but not isolated. And by that I mean that dynamic, that sort of intertwining, and that sort of almost collaborative engagement is happening with dozens, maybe hundreds of groups. And so it's just, at least in my experience, it was never the case that the government had sort of pride of place in those discussions, with the possible exception of national security issues. Although even there were a lot of folks who had a lot of important information to share that were not associated with the government. And so, that's sort of, I think, part of my just relative ease or comfort with the dynamic you're describing. And then the other thing I'll say is, I did mention lack of accountability. That, in terms of speech decisions that are made by these companies, it's not. There is one bit of accountability, which is that everybody, anytime it's politically charged, the kind of the side whose ox is getting gored sees it very quickly. They see it in the reach of their pages, they see it in their impressions, and they go bat blank crazy. I mean, they are extremely vocal. And so the minute you sort of alter an algorithm or adopt a policy that's going to disfavor one side in a charged area, you're hearing it very loudly from the other side. And I think that's true regardless of what the genesis of the change is. So that also gives me some comfort that there's not a sort of a inevitable creep in the nature of these decisions that would be unnoticed. Good to see you, Randy.
See you, Randy.
So I guess one last question that's being touched on a bit is, but just a bit, and Kathy, you said in your last comment, the role for Congress, because we've talked about the executive branch, we've talked about the social media companies, but is there a role for Congress here in the sense of, could there be statutory reforms that would potentially regulate how government interacts with the companies? Or, Colin, flipping it to you as well, what do you think about legislation that does in fact require some forms of transparency on the part of the social media companies, if that's something that could also help fix at least the levels of distrust?
Well, the question of liability, right? Like that's the big question. Yeah, I know. Well, that's the big question, and that would make a big difference, right? Because then these plaintiffs'
Yeah.
beef would be with the social media companies, not with the government officials. And so that would certainly simplify the world and make it look kind of a lot like a lot of other things. And, you know, and that obviously will continue to be a source of, you know, of debate. I think it's difficult to be too prescriptive. If you think about just even this scenario, let's assume that the Supreme Court upholds the Fifth Circuit opinion and actually says, yeah, you know what, the government crossed a line here. Okay. Like what, so? I honestly, I think that's probably would be a bit of, you know, the White House's reaction. Well, there's no damages, right? You can't get economic damages in a case like this. And so the White House says, okay, you know, my bad, we crossed the line. But by the way, they probably would say, I'd do it again, because this was an urgent health crisis, and we were going to do everything we could to ensure that the people of the United States were fully informed with factual information. So, I think that, and I have to say that probably in another situation, would it affect future government officials' behavior? Sure. But probably, you know, a little bit on the margin, again, depending on where the Supreme Court, you know, draws the line. So to me, I think there's probably not, other than really dealing with the big elephant in the room, which is, should the social media companies have some liability for these decisions that they make? I don't think there's probably a lot, I haven't given it a huge amount of thought, but I don't think there's probably a lot more that Congress could do. But that's obviously a big deal that would make people in the tech world pretty unhappy.
I mean, I think that the Biden administration screwed up here, no question about it. There's a hard question about whether any particular interaction crossed the constitutional line, but you know, Kathy.
No, I would not
you know,
advise.
you would not say that. Maybe you wouldn't use the phrase I just did, but you know, you've already said that you would have advised them to act differently than they did, at least in some of those contexts. And it's worth remembering that I said at the beginning, and this is true, I'm very sympathetic to the Biden administration's effort at a kind of high level, but they got some important things wrong, and it's not surprising. It was in the middle of a crisis, and it wasn't clear what the right facts were, and they thought one thing was true, and it turned out that something else was true. That's always going to happen, but that's a reason to build a system that preserves the possibility of dissent and counterweight, and the rule against coercion is meant to do that. And if the Supreme Court comes out with a rule that says, in a public health crisis, the government can override they're not going to do this, but override the editorial decision-making of social media platforms, that would be a bad thing, precisely because it's a public health crisis, and we need to make sure that collectively we make good decisions. And the way we do that is to preserve the space for dissent.
Great. Well, please join me in thanking the panel.